Fact-finding hearings, the procedural pivot point. When what is excluded from findings disappears from protection. This is the moment in family proceedings that quietly determines the trajectory of almost everything that follows. Now, the final hearing, not judgment, not enforcement, but the moment where the court decides what happened, what did not happen, what is relevant, and what will officially exist inside procedural record. That moment is the fact-finding hearing. And despite how critical it is, many survivors enter this phase without full understanding of its long-term significance, because a fact-finding hearing is not simply about telling your story. It is about evidential recognition, safeguarding architecture, procedural legitimacy, and the future lens through which the entire case may thereafter be viewed. What is included in the finding influences child arrangements, safeguarding analysis, credibility, professional reports, participation treatment, enforcement, and procedural participation moving forward. But equally important is this: what is excluded from findings frequently disappears from protection. This is one of the least understood structural realities within family proceedings, because where abuse is minimized, deemed irrelevant, insufficiently evidenced, procedural exclusion, or administratively compressed, the practical safeguarding consequences can be extremely profound. This masterclass examines fact-finding hearings, evidential thresholds, procedural culture, coercive control, trauma-informed justice, procedural discretions, and the structural consequences of non-findings inside family court proceedings. This is not about attacking the court. This is about examining the process and how procedural systems shape institutional realities. I'm Samantha, your host of Silence Screams Loud Strength. This is Unmasking Justice. So, let's begin. I'm smiling, but this is a very serious issue. What is fact-finding hearing? Actually, what is it? What does that actually mean? Fact-finding hearings exist to determine disputed allegations relevant to the welfare issues before the court proceedings start. So in principle, this serves as an important purpose, an important process within which the family courts will understand, or the court actually must understand, the risk, the harm, the abuse, the behavior, and the safeguarding concerns before making decisions affecting children and families, especially women who've been affected by domestic abuse. But the process therefore appears evidential, rational. Okay, but the operational reality is far more complex, because family proceedings do not function like criminal proceedings. The evidential threshold differs, the procedural culture differs, the time structures differ, and most importantly, the court frequently operates under substantial administrative pressure. This creates an important structural issue. Fact-finding hearings are not merely legal exercises. They are institutional filtering mechanisms. The court determines which allegations proceed, which allegations matter, which allegations are relevant, and which allegations become secondary, procedural secondary in the process. That filtering process has enormous safeguarding implications because abuse is often contextual, accumulative or cumulative, relational, psychological, and longitudinal, yet proceedings frequently require concise allegations, procedural narrowing, evidential compression, and issue reduction. This creates risk, particularly in coercive control cases where the abuse may not consist of an isolated dramatic incident, but of ongoing psychological dominance. That is the distinction. Coercive control is not one event, it's accumulative. So until the courts understand that, they will continue to make this problem. The relevance problem, now let us just discuss one of those most important concepts inside family proceedings. Relevance, on paper, relevance appears sensible. Courts cannot legitimate everything, aspect of every relationship. Courts cannot legitimize every aspect of every relationship. Procedural focus matters, but the difficulty is this: coercive control often cannot be understood incident by incident. It exists through pattern, atmosphere, cumulative destabilization, fear, unpredictability, intimidation, surveillance, financial domination, emotional erosion, and psychological conditioning over time. This creates a structural contradiction. The legal system often asks, what specific incident are you relying upon? But coercive control frequently operates through accumulated pattern rather than isolated incident. So when proceedings become heavily compressed around narrow allegations, isolated incidents, or administrative efficiency, there is a massive risk that context disappears. This is profoundly important because safeguarding analysis without contextual continuity becomes vulnerable to distortion. A survivor may therefore experience the exclusion of historic context, the narrowing of allegations, or the procedural minimization of relational patterning. And once it's excluded procedurally, those dynamics frequently lose safeguarding visibility moving forward. So this is why what is excluded from findings may effectively disappear from protection within family modern courts. So trauma, memory, and factual presentation. Fact-finding hearings are heavily reliant upon recall, chronological, evidential consistency, narrative clarity, and witness presentation. But trauma frequently disrupts precisely those functions. Trauma does not always produce linear memory, calm testimony, organized chronologically, or emotionally regulated evidence. Instead, trauma may impair sequences, recall, concentration, verbal fluency, emotional regulation, and cognitive processing under pressure. Now, consider what happens inside proceedings. Inside adversarial proceedings, actually, because the survivor is expected to recall painful events, withstand challenge, remain emotionally regulated, process procedural complexities, and perform credibility under stress. This creates significant evidential risk because trauma responses may be misinterpreted as inconsistency, aggravation, instability, confusion, or unreliability. This is not a minor procedural issue. It directly affects judicial findings themselves. And where findings become distorted by trauma-related participation impairment, the safeguarding consequences may extend far beyond the hearing, because future proceedings frequently rely heavily upon earlier findings. This means the fact-finding hearing may become the procedural foundation upon which all future safeguarding, misinterpretation, or interpretation rests. So the no finding problem. Yes, the no finding problem. Now let us discuss one of those most dangerous phrases inside family proceedings. No findings were made. This phrase carries enormous institutional power. No findings were made, because professionally and procedurally, absence of findings may gradually become interpreted as absence of harm, absence of abuse, absence of risk, or absence of safeguarding concern. But these are not the same things. No findings may arise because evidence was excluded, participation was impaired, allegations were narrowed, procedural time was limited, trauma affected presentation, disclosure remained incomplete, or the evidential threshold was not reached. This distinction matters enormously because the absence of findings is not always the same as the absence of abuse. Yet, institutionally, systems often gravitate towards procedural simplification, and procedural simplification may unintentionally arise complexity. This creates enormous safeguarding concerns in coercive control cases where absence may be difficult to evidence continually. Pattern matters more than incident, and trauma affects participation quality. The issue, therefore, becomes how should safeguarding systems interpret non-findings within complex abuse cases? The question remains insufficiently developed institutionally. So the question remains insufficiently developed institutionally. Judicial discretion and structural pressures. Family court justice operates under enormous pressure. That pressure is compressed because of time. This must be acknowledged honestly. Heavy court caseloads, time constraints, backlogs, pressure, complexity, safeguarding demands. Complex safeguarding demands resource limitation. This issue is not simplistic and is not blame. This issue is structural pressure because coercive control cases require contextual analysis, evidential patience, psychological sophistication, and safeguarding continuity. Without that, the family courts will continue to let victims of domestic abuse down. But procedural systems often reward efficiency, narrowing, progression, and disposal. This creates institutional tension, particularly where complexity is administratively difficult, allegations are extensive, or contextually evidence requires time-intensive analysis. The danger is that procedural management may begin displacing safeguarding depth. And once that occurs, findings risk becoming shaped by not only by evidence, but by institutional compression itself. This is one of the least discussed structural realities inside family court justice systems. CAFCASS, social services, and the findings landscape. The impact of findings extends far beyond the hearing itself. CAFCASS, social services, experts, schools, future proceedings, all may rely heavily upon finding landscapes established by the court. This creates profound institutional consequences because findings often become the procedural reality through which all future safeguarding concerns are interpreted. Where abuse findings exist, safeguarding visibility increases. Where findings are absent, institutional skepticism may increase, concerns may become minimized, and future disclosures may encounter procedural resistance against it, not always maliciously. It is structural. Systems require reference points. But where these references or reference points are incomplete, compressed, or contextually fragmented, future safeguarding analysis may also become distorted. This is why fact-finding hearings are not isolated procedural events. They are long-term safeguarding architecture, safe chain, and evidential continuity. The central problem exposed by fact-finding hearings is this: safeguarding remains heavily dependent upon fragmented evidence, procedural compression, discretionary interpretation, and institutional discontinuity. SafeChain proposes a fundamental different framework, one based on, not upon isolated procedural moments, but upon evidential continuity. This means contextual safeguarding, cross-system pattern visibility, participation integrity, disclosure continuity, trauma-informed procedural analysis, and longitudinal safeguarding infrastructures within the family court systems, or any court systems actually. So SafeChain argues that coercive control cannot be reliably understood through isolated procedural snapshots alone. It requires pattern recognition, contextual continuity, and structural integrated safeguarding analysis across proceedings, all proceedings. Without that, systems remain vulnerable to fragmentation, procedural distortion, and evidential collapse through administrative compressive process. Fact-finding hearings are not merely procedural stages. They are evidential gatekeepers or gateways, safeguarding foundations, and institutional reality shaping mechanisms. What is recognized becomes visible. What is excluded may disappear procedurally for years. That is why participation matters, context matters, trauma-informed analysis matters, and safeguarding continuity matters. The future of family justice cannot rely solely upon procedural efficiency, evidential compression, and fragmented interpretation. It must evolve towards structural integration, safeguarding, because children deserve systems capable not merely of processing conflict, but of recognizing harm accurately, contextually, and safely. I am Samantha. This was Silence Screams Loud Strength. Unmasking Justice, Masterclass 7, Fact-Finding Hearings, the Procedural Pivot Point. This is part of Silence Screams Loud Strength, the podcast, which streams on all platforms wherever you listen to your podcast from. So for other episodes, please visit Silence Screams Loud Strength, or watch your podcast on YouTube, or read the directive on safechain.org, the website. Subscribe on YouTube so you get a notification when the next masterclass drops. Pre-order Unmasking Justice from SafeChain. Join the Masquerade Gala on the 30th of October. Reserve your ticket now. I can't do this alone. This is for all of us. Let's march together for a safer, more safeguarded legal system. This is SafeChain and Samantha. If this episode resonated with you, please share it with those that needs to hear it. Until next time, thank you.